Good morning, everybody. On behalf of Chandigarh Judicial Academy, I, Harshali Chowdhary, Additional District and Sessions Judge, cum faculty member, Chandigarh Judicial Academy, welcome you all. In this session, we shall be taking up the important judgments for the month of December 2022. So without further ado, let's start with the important judgments. The first judgment is from Civil Procedure Code 1908. The judgment is Solomon Selvaraj versus Indrani Bhagwan Singh. In this case, the plaintiffs filed an application to suit as indigent persons under Order 33, Rule 1 CPC. The trial court dismissed the application because the suit was vexatious and abuse of process and barred by res judicata. Honorable Madras High Court upheld this order. Thus, the plaintiffs appealed before Honorable Supreme Court. It was held that when the plaintiff does not disclose any cause of action and the suit is barred by res judicata, the trial court did not err in dismissing the application to sue as indigent persons. Observations that the suit is barred by res judicata and or no cause of action will only affect the indigent person application. If the indigent person application is granted, the suit must be numbered and recorded. Until then, the plaint or suit is pre-numbered and pre-registered. The next judgment is from contract. The judgment is Wave Industries Private Limited versus State of UP and others. In this case, UP State Sugar Corporation Limited and the appellant buyer entered into a slump sale agreement and sale deed. The appellant bid for rupees 13.94 crores and under the slump sale agreement, all liabilities accruing before the date of signing were to be borne by the seller and those of subsequent periods by the buyer. Unpaid duty, penalty, and interest were disputed. Honorable Supreme Court had to decide whether seller or buyer should pay outstanding liabilities. It was held by Honorable Supreme Court that there was no dispute that the disputed duty related to business transactions before the slump sale agreement was signed. The court noted that the business liability arose from the unit's operation before it was sold to the appellant, but it will be quantified and discharged later. While noting that the liability in question was not contingent, the court held that the purchaser who was not operating the unit before the slump sale agreement cannot be held liable. The court ruled that the appellant could not be held liable for the purchases due for the unit's activities and operations prior to the signing date. The next judgments are from Criminal Procedure Code 1973. The first one would be Ikram versus State of Uttar Pradesh. In the present case, Additional District Judge 1 Hapur by 9 separate judgments delivered on the same date convicted and sentenced the accused who had agreed on plea bargaining for 2 years, simple imprisonment and a fine of rupees 1,000 in each of the cases involving theft of electricity equipment belonging to the state of Uttar Pradesh. The trial court in all the 9 judgments directed that the undergone period of 21 months in custody of the accused person be set off against the period of sentence. However, the jail authorities treated the sentences to be counted in the subsequent case only after the completion of jail term in the earlier case. On being aggrieved, the convict petitioned before Honorable Allahabad High Court, praying that sentence awarded should run concurrently. However, his prayer was refused on the ground that in view of the provisions of Section 427 of the Code of Criminal Procedure, each subsequent term of conviction has to commence at the expiration of the imprisonment currently being undergone by the appellant. The petitioner thereafter approached Honorable Supreme Court with a plea of habeas corpus. Supreme Court allowed the appeal and set aside the judgment of Honorable High Court, thereby directing that sentences which have been imposed on appellant in 9 sessions trial shall run concurrently. The jail authorities shall act immediately on production of certified copy of the order. Reference was also made to the case of Muhammad Zahid versus State through NCB, wherein the provisions of Section 427 CRPC were interpreted as following. If a person already undergoing a sentence of imprisonment is sentenced on a subsequent conviction to imprisonment, Such subsequent term of imprisonment would normally commence at the expiration of the imprisonment to which he was previously sentenced. Ordinarily, the subsequent sentence would commence at the expiration of the first term of imprisonment unless the court directs the subsequent sentence to run concurrently with the previous sentence. The general rule is that where there are different transactions, different crime numbers, and cases have been decided by the different judgments, concurrent sentences cannot be awarded under Section 427 CRPC. Under Section 427, subsection 1 of CRPC, the court has the power and discretion to issue a direction that all the subsequent sentences run concurrently with the previous sentence. However, discretion has to be exercised judiciously depending upon the nature of the offense or the offenses committed and the facts and situation. However, there must be a specific direction or order by the court that the subsequent sentence to run concurrently with the previous sentence. P. Ponnuswamy versus State of Tamil Nadu was the judgment which was passed by Honorable Supreme Court in the month of November 2022, and it was circulated by our own Punjab and Haryana High Court, in which the Supreme Court, to the ratio of 2:1, held that an accused has a right to receive the list of documents, material, statement, etc. in the possession of the prosecution, even if draft rule of criminal practice are not yet adopted. The next case is Kalicharan versus State of UP. In this case, Honorable Apex Court examined two issues as to whether there is a failure to comply with the requirements of Section 213 and 313 CRPC in the case in hand. And if in affirmative, the next question would be whether prejudice has been caused to the accused due to failure to comply with the aforesaid provisions and whether it has caused a failure of justice. It was held by the court that the purpose of charge framing is to allow the accused to defend himself properly. An accused can effectively defend himself if he is apprised of the allegations against him before trial. The bench remarked that in this case, evidence suggests that the accused murdered the victim with sharp instruments, but there is no murder charge. Section 213 charges must state how the accused committed murder. It was also observed that when the Court of Appeal is called upon to decide whether any failure of justice has been occasioned due to omission to frame a charge or error in the charge, the court is duty bound to examine the entire record of the trial, including all exhibited documents, depositions, and the statements of the accused recorded under Section 313. Section 313 CRPC questioning is not a formality. The accused must be briefed about the evidence against him so he can offer an explanation. After being questioned under Section 313 CRPC, an accused may examine defense witnesses and provide other evidence if the accused is not explained about the significant evidence against him on which his conviction was based. It was held that the failing to establish a proper charge under Section 213 of CRPC and failing to include incriminating evidence in the statement under Section 313 CRPC prejudiced the accused. The court allowed the appeal and acquitted the accused. In the case of Sanjay Singh versus State of Bihar, the Supreme Court had observed that criminal cases cannot be converted into money recovery proceedings, and granting bail to the accused on condition of making payment in certain mode or installments must be disapproved. In this case, the petitioner had initially approached Honorable Patna High Court for obtaining anticipatory bail in connection with an FIR registered against him. Honorable High Court required the accused to deposit a demand draft of rupees 50,000 favoring the informant in addition to the furnishing of bail bond. Honorable Supreme Court, although did not interfere with the grant of pre-arrest bail to the petitioner, but stayed the operation of the Honorable High Court's order to the extent that the petitioner was required to deposit payment in installments. The next case is Chandipulia versus State of West Bengal. In this case, the accused filed a discharge application under Section 227 and Section 301 CRPC. He claimed that he was acquitted of the offense of kidnapping and was now being charged for murder based on the same facts. This was dismissed on the ground that such an objection can be filed at the stage of charge and not discharge. Honorable Calcutta High Court upheld the order In appeal, the accused argued that the discharge under Section 227 CRPC was a stage before charge and that the court can only examine an application under Section 300 CRPC. Once the court rejects the discharge application, it would continue to framing of charge under Section 228 CRPC, and the only question before it would be the nature of the offense and not the accused has not committed an offense or that he cannot be tried under Section 300 CRPC. Honorable Supreme Court held that the accused plea on applicability of Section 300 CRPC has to be considered at the stage of discharge under Section 227 CRPC only. The next judgment is of Sukhpal Singh Khera versus State of Punjab. It was held in this judgment that the power under Section 319 CRPC is to be invoked and exercised before the pronouncement of the order of sentence where there is a judgment of conviction of the accused. In the case of acquittal, the power should be exercised before the order of acquittal is pronounced. Hence, the summoning order has to precede the conclusion of the trial by imposition of sentence in the case of conviction. The trial court has the power to summon additional accused when the trial is proceeded in respect of the absconding accused after securing his presence, subject to the evidence recorded in the split-up trial pointing to the involvement of the accused sought to be summoned. But the evidence recorded in the main concluded trial cannot be the basis of the summoning order if such power has not been exercised in the main trial till its conclusion. Certain guidelines have also been laid out with regard to the competent court which should follow while exercising the power under Section 319 CRPC. We have a separate case note on this judgment. The guidelines and the other observations made by Honorable Supreme Court can be looked into from that case note. Another judgment is State of Punjab versus Pankaj Kumar alias Panky and another. The question before Honorable Supreme Court was whether the instructions dated 4th of May 2017 issued by the Department of Home Affairs and Justice, Punjab, for separation of investigation from law and order in Punjab Police could have been set aside by Honorable High Court in the applications for bail filed by the accused under Section 439 CRPC. It was observed by Honorable Supreme Court that there is a substance in the argument that the instructions had been quashed without effective notice to the state to come and defend or support the instructions. The said order was set aside insofar as the same quashes the instructions dated 4th of May 2017. It was also made clear that the observations made in the impugned judgment and order with regard to the procedure of the investigation and or the circulars will not operate as a precedent in future or otherwise influence the investigation. The next case pertains to the Deficiency of Services under Consumer Protection Act 1986. It is Gokal Chand and others versus Axis Bank and others. The appeal stemmed from a home loan secured by the appellants for which the life insurance in the deceased name was a prerequisite. Respondent number 1, acting as an agent for respondent number 2, sanctioned a house loan of approximately 70 lakhs. From the granted loan amount, the bank paid the insured insurance premium of rupees 6,24,172 rupees. Borrower settled the loan during the appeal. Respondent number 2 refused to settle the loan account when the insurance claim was made after the insured died of cardiac arrest. The appellants filed a complaint with Haryana State Consumer Dispute Redressal Commission. The State Commission dismissed the consumer complaint because the insurer and the insured lacked privity of contract. The National Commission also rejected the appeal. The angry appellants went to Honorable Supreme Court. It was held by Honorable Supreme Court that respondent number 2 acted with malified intentions after learning of the insured person's death from the affected parties. Respondent number 2's response to the information fails the reasonable conduct test. To cover their late reaction, an antedated letter with an unfounded medical reason was sent. These are clear cases of service deficiency and non-bona fide behavior by the respondent number 2. The bench set aside the National Consumer Dispute Redressal Commission's judgment being unsustainable. The next case is from Drugs and Cosmetics Act 1940. It is Hansmukh Lal D. Vora and another versus State of Tamil Nadu. In this case, in the year 2013, a drug inspector inspected the appellant's premises and accused a violation of Section 18C of 1940 Drugs and Cosmetic Acts and Rule 6551B of the 1945 Drug and Cosmetic Rules. A show cause notice was issued over 3 years after the probe into the appellant began, and a complaint was filed in 2016. The appellant then sought quashing of the complaint under Section 482 CRPC, which the Honorable High Court denied. The appellant petitioned before Honorable Supreme Court. It was held by Honorable Supreme Court that unexplained unreasonable delay can be grounds for quashing a criminal complaint. Honorable Supreme Court said that the respondent had not explained the 4-year delay between the initial site inspection, the show cause notice, and the complaint. After more than 4 years between the initial investigation and the complaint, no evidence has been provided to support the claims. In fact, the lack of explanation leads the court to suspect a malicious motivation. Accordingly, the appeal was allowed and the order passed by Honorable High Court was set aside. Another case is from Hindu Marriage Act 1956. It is Priyanka versus Santosh Kumar. In this case, the husband filed a petition under Section 9 of the Hindu Marriage Act 1955 against the wife in Puducherry. In these proceedings, he filed an interlocutory application for child custody under Section 26 of the Act. Both applications were granted ex parte. The wife then asked the Honorable Supreme Court to move the case to Bangalore. The husband argued that the wife's Section 9 petition had already been decided, making the transfer petition moot. It was held by Honorable Supreme Court that in proceeding under Section 9 of Hindu Marriage Act, visitation privileges or temporary child custody cannot be granted. The court invoked Article 142 of the Indian Constitution and set aside the order. The court thereafter transferred the case to Bengaluru's Family Court. The next case is from Hindu Succession Act 1956. It is Kamla Neti versus Special Land Acquisition Officer. In this case, the Land Acquisition Reference Court denied a woman's claim to a share of the compensation. The main reason was that the parties were from scheduled tribe community, so the Hindu Succession Act did not apply. Since she was a daughter, she did not have the right to share of the compensation. Honorable Odisha High Court agreed with this point of view. It was held by Honorable Supreme Court that although it was held that under the circumstances in view of Section 2, subsection 2 of Hindu Succession Act and the appellant being the member of the scheduled tribe and as the female member of the scheduled tribe is specifically excluded, the appellant is not entitled to any right of survivorship under the provisions of Hindu Succession Act. No error has been committed by the Honorable High Court. The appeal therefore deserves to be dismissed and is accordingly dismissed. However, the bench urged the central government to consider whether it is necessary to bring a suitable amendment to Hindu Succession Act. The next case is from the Indian Evidence Act 1872. It is Rajaram versus State of Madhya Pradesh and another. In this instance, the hospital recorded that a burnt woman was brought there by the appellant. Police station Ashoknagar, Guna MP requested the wounded person's MLC. She also got recorded 2 dying declarations, burnt kerosene scented garments, a chimney, a damaged Mangalsutra, and 3 to 4 matchsticks were seized. Witness statements and a spot map were made. A postmortem was conducted and the seized items were forwarded to FSL. After investigating, the police charged the appellants under Section 302, 307, 304B, 498A, read with 34 of IPC and Section 3 and 4 of the Dowry Prohibition Act. The court charged the remaining accused and examined 15 witnesses. The trial court convicted and punished the appellant and others for Section 498A IPC. The appellant and other accused appealed before Honorable Madhya Pradesh High Court. However, the Honorable High Court denied their appeals and the matter was before Honorable Supreme Court. Honorable Supreme Court acquitted the appellant on the basis that the second dying declaration was the only piece of evidence that named the appellant as one of the perpetrators of cruelty on the deceased along with the other accused. The next judgment is from Indian Penal Code 1816. It is Ram Pratap versus State of Haryana. Ram Pratap was one of the accused in the murder case. He was convicted by the trial court under Section 302 of Indian Penal Code and same was upheld by Honorable Punjab and Haryana High Court. In appeal, Honorable Supreme Court noted that the case was based on circumstantial evidence. The bench referred to Sharad Birdi Chand Sharda versus State of Maharashtra, in which it was observed that suspicion, howsoever strong, cannot substitute proof beyond reasonable doubt. Taking note of the evidence on record, the bench allowed the appeal and acquitted the accused. Another case is from Jandel Singh versus State of Madhya Pradesh. In this case, the Honorable Supreme Court converted the conviction of two convicts under Section 302 IPC to Part 1 of Section 304 IPC because the incident was spur of the moment. The appellant sought their Section 302 IPC conviction converted to Section 304 IPC Part 1 or Part 2. The state of Madhya Pradesh opposed the prayer, arguing that the appellant had assaulted the deceased on his head, a vital part, and the intention was to cause death was obvious. Honorable Supreme Court observed that FIR would show that the parties had a heated argument that led to a sudden quarrel. The appellant used a stick and the other used Carrera. The Honorable Madhya Pradesh High Court upheld the trial court's order convicting the appellant under Section 302, read with Section 34 IPC, noting that they had intended to commit murder, but Honorable Supreme Court converted that conviction from 302 IPC to Part 1 of Section 304 IPC. Now, the next case laws are from labor laws. For the first one would be D.N. Krishnappa versus the Deputy General Manager. In this case, the appellant worked for the bank respondent. He was dismissed in departmental proceedings. Appellant contested dismissal order. The labor decision reversed his dismissal and ordered reinstatement and 50% back pay. The bank and the appellant disputed the award in before Honorable High Court. Honorable High Court confirmed reinstatement but decreased back pay from 50% to 25%. In the appeal, Honorable High Court Division Bench maintained the Labor Court's restoration ruling, but ruled that the appellant was not entitled to back wages. 2013 saw the appellant's reinstatement. Despite a July 2007 award, he was neither reinstated nor paid full salary, so he returned to the Labor Court. The Labor Court ordered the bank employer to pay salaries from the award date to reinstatement. Bank approached Honorable High Court. By the challenge judgment and order, Honorable High Court struck aside the Labor Court order and found that it lacked jurisdiction to decide the employee claim. The employee appellant petitioned before Honorable Supreme Court. Before Honorable Supreme Court, it was held that the interim order is always subject to the final order granted after the proceedings end. Final decisions always override interim orders. Because there was an interim order or stay of reinstatement during the proceedings, an employee appellant cannot be refused back wages after the order of reinstatement is confirmed by the court. In this instance, the Honorable High Court Division Bench confirmed the reinstatement order. Therefore, the order of reinstatement will refer back to the original Labor Court order. Because the reinstatement order was challenged and stayed throughout the Honorable High Court proceedings, it cannot be used to deny wages to the employee when the order was confirmed and became final. Accordingly, Honorable Supreme Court set aside the High Court's Division Bench order. The next case is Kirloskar Brothers Limited versus Ramcharan. In this case, the appeal has been preferred against the order of the Industrial Tribunal and Honorable Madhya Pradesh High Court, wherein the court had ordered reinstatement of the concerned respondent as they were the employees of the appellants. Apparently, the contestant respondents were contractual laborers of the respondent number 7, the contractor who was engaged by the appellant in terms of contract. And upon entering into the contract, necessary compliances under CLRA Act was completed by the appellant and the respondent number 7. The labor contract came to an end and the services of the respondent were dispensed with by the contractor. The respondents, aggrieved by their termination, approached the labor court seeking reinstatement in service, which was rejected by the labor court and further were reinstated by the Industrial Tribunal and then by Honorable Madhya Pradesh High Court. It was held by the Honorable Supreme Court that in absence of any notification under Section 10 of CLRA Act and unless there are allegations or findings with regard to the contract being sham, respondents cannot be held to be the employees of the appellant and not of the contractor. The apex court further stated that both the industrial tribunal as well as the High Court have committed a serious error in reinstating the contesting respondents and directing the appellant to absorb them as their employees, as there was no notification under 10 of CLRA Act, and that there was no allegation that the contract was sham. Accordingly, the appeal was allowed and judgment passed by the High Court and the industrial tribunal were quashed and set aside. Another set of judgments are from Land Acquisition Act 1894 and Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. One of the cases is New Okla Industrial Development Authority versus Omvir Singh. In this case, an appeal was filed against the judgment and order of Honorable Allahabad High Court, which condoned the 16-year delay in filing the first appeal against the rejection of review request to increase the compensation awarded and increase the compensation payable to the landowners to rupees 297 per square yard for the land acquired in 1982 for the Noida's planned development. It was held regarding their condemnation of delay. The apex court declined to interfere in the High Court decision. However, Honorable Supreme Court modified the compensation awarded to the original claimants by Honorable Allahabad High Court and reiterated that the claimants were not entitled to the same compensation as was awarded for the lands acquired after 5 years under the Land Acquisition Act 1894. Asha Ram dead through Ellas and others versus UP Awas Awam Vikas Parishad and another. Narendra and other versus State of UP and others were referred to. In plethora of cases by Honorable Supreme Court, Honorable Supreme Court had reiterated that the land acquisition proceeding shall not lapse if the award is not made as on the commencement of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. In the case of Manhar Lal Shiv Kumar Panchal versus the Deputy Collector and Land Acquisition Officer, it was held that in view of the liberty reserved by the Honorable High Court in favor of the appellants to pursue such remedy as may be available to them for enhancement of compensation, the reference application could not have been dismissed as barred by limitation under Section 18, subsection 2 of the Act 1894. Within a period of 6 months from the date of dismissal of the special leave petition, the reference was filed. Hence, the observation made by Honorable High Court that it is too late to make the grievance with respect to the inadequacy of the compensation. Those observations are to be read while considering the prayer of the appellant challenging the acquisition proceedings. It appears that the acquisition was also challenged on the ground that the amount awarded is inadequate. To that, the observations were made by the High Court that it is too late to raise such a dispute. Therefore, the High Court ought to have interfered with the decision of the reference court dismissing the reference on the ground of limitation and ought to have remitted the matter to the reference court to decide the reference on the merits. Haryana State Industrial and Infrastructure Development Corporation Limited and others versus Mr. Deepak Agarwal and others was a judgment passed by Honorable Supreme Court and circulated by Honorable Punjab and Haryana High Court, in which the meaning and interpretation of the word initiated employed in Section 24, subsection 1 of the Right to Fair Compensation and Transparency in the Land Acquisition, Rehabilitation and Resettlement Act 2013 with reference to land acquisition proceeding under the Land Acquisition Act 1894 was the issue in hand. A scanning of Section 24, subsection 1A would reveal that if land acquisition proceeding was initiated under the Land Acquisition Act, but no award was passed under Section 11 thereof, then all provisions of the 2013 Act relating to the determination of the compensation would apply. At the same time, if upon the initiation of the acquisition proceedings under the LA Act, an award under Section 11 of the LA Act was passed, then such proceedings shall continue under the provisions of the LA Act itself, as if the same had not been repealed. It was held that the point of initiation of land acquisition proceedings under the Land Acquisition Act for the purpose of Section 24, subsection 1 of 2013 Act is issuance and publication of Section 4, subsection 1 notification in the Official Gazette of the appropriate government. Clause A of subsection 1 of Section 24 of 2013 Act is applicable. The proceedings shall continue as per the LA Act. However, only for the determination of compensation amount, the provisions of 2013 Act shall be applied. The next case is from Maintenance and Welfare of Parents and Senior Citizens Act 2007. It is Sudesh Chikara versus Ramrati Devi and another. In this case, respondent number 1 claimed that she inherited land from her father. Respondent number 1 then released part of the property to her daughters. The release deed gave each daughter 1/3 portion of the property. Then her son received another release deed. Respondent number 1 executed a release deed in behalf of her son on the same day. All the release deeds were registered. Respondent number 1 and others disputed the last and third deeds in court. The court nullified the release document. According to respondent number 1, her son and grandson appealed a decree and sold the property during the appeals. Respondent number 1 filed a Section 23 petition with the Maintenance Tribunal. In the petition, respondent number 1 asserted her relationship with her son and daughters was strained and they were not maintaining her. Respondent number 1 claimed her release deed was invalid and void. Section 23 of 2007 Act was invoked to rescind the release deed. The children opposed respondent number 1 Section 23 petition. The Maintenance Tribunal ruled that respondent number 1's children were not willing to take care of her and declared that the release deed was null and void. The Honorable High Court upheld the Maintenance Tribunal order on appeal. The children petitioned before Honorable Supreme Court. It was held by Honorable Supreme Court while setting aside the orders passed by Honorable High Court and the Tribunal that effectuating the transfer of property to children subject to a condition of maintaining senior citizen or parent is not necessary under Section 23, subsection 1 of the Maintenance and Welfare of Parents and Senior Citizen Act 2007, and that existence of such condition must be established before the tribunal. Since effecting the release deed in favor of the children by way of release deed was not subject to take care of the respondent number 1 as envisaged under Section 23 of the Act. In fact, there was no such condition on the release deed. The release deed cannot be held nullity on this ground. A few cases from motor accident compensation claims. The first one would be Harpreet Kaur and others versus Mohinder Yadav. In this case, the appellants are agreed by Honorable High Court of Punjab and Haryana's final judgment, which partly allowed their first appeal and increased the petitioner's compensation from 6,60,000 with 6% interest to 17,66,000 with 7.5% interest. The appellant's grievance was that the High Court erred in computing compensation for loss of income and failed to award any amount for loss of love and affection under the Motor Vehicles Act 1988. It was held by Honorable Supreme Court that the total income assessed as 1,50,000 rupees from 95,000 rupees, which is on account of amount being received from his agricultural land that he cultivated and the additional land that he was getting cultivated. It was also held in view of Magma General Insurance Company versus Nanu Ram, the filial, and consortium amount was increased. The appeal was accordingly allowed and the judgment was modified to the above mentioned extent, while the rate of interest and other components directed to be payable were left undisturbed. In other cases, Mohammad Sabir alias Shabir Hussain versus Regional Manager. In this case, the Motor Accident Claims Tribunal awarded the complainant rupees 15,76,465 rupees. Honorable Delhi High Court allowed the appeal and by increasing the compensation to 16,70,932 rupees. In appeal, Honorable Apex Court acknowledged the claimant's 70% permanent handicap and imputed right lower leg. Honorable Supreme Court allowed the appeal and granted the claimant rupees 38,70,120 rupees plus 9% interest per year from the date of application. The Honorable Supreme Court noted that marginalized people with disabilities experience further prejudice. Socioeconomic background of the claimants must be considered while awarding the compensation in cases of permanent disability. Next case is of Rajwati alias Rajo versus Union India Insurance Company Limited. In this case, the deceased heirs and dependents appealed to the Honorable Supreme Court against Honorable High Court of Rajasthan's decision to lower the compensation awarded by the Motor Accident Claims Tribunal. Honorable High Court refused to consider the deceased salary certificate and pay slip says the issuer was not examined. It was held by Honorable Supreme Court, thereby reiterating that strict rule of evidence as applicable in a criminal trial are not applicable in motor accident compensation cases. The court said that the documents produced by the claimants are conclusive proof of the income of the deceased and were also corroborated by the statements of the deceased wife and his co-workers. Another case is Anjali versus Lokendra Rathod. In this instance, the claimants produced the deceased income tax return before the tribunal showing a total income of rupees 1,18,261 or rupees 9,855 per month. The MACD rejected it because no ITRs or other income documents were filed before 2009-2010. It set his salary at rupees 4,000 per month or rupees 48,000 per year. Honorable High Court refused to examine ITR on appeal and calculated the deceased income at rupees 5,000 per month. The claimant approached Honorable Apex Court challenging the same. It was held by Honorable Supreme Court that income tax return is a statutory document on which the reliance be placed where available for computation of annual income of deceased. Reliance was also placed upon Malar Vizhi and others versus United India Insurance Company Limited. The next case is from Prevention of Corruption Act 1988. It is Neeraj Datta versus State Government of NCT Delhi. In this case, the constitutional bench of Honorable Supreme Court answered the reference on whether circumstantial evidence can be used to prove demand of illegal gratification. It was held that in the absence of evidence of the complainant, direct or primary, oral or documentary evidence, it is permissible to draw an inferential deduction of culpability or guilt of a public servant under section 17 and section 13 subsection 1D read with section 13 subsection 2 of the Act based on other evidence adduced by the prosecution. Again, we have a detailed case note on this case law on our YouTube channel. You may look into that case note for further reference. The next cases are from service jurisprudence. The first one would be CISF and others versus Santosh Kumar Pandey. In this case, appellant, a CISF constable assigned in Vadodara's Greenbelt area, was charged with misbehavior in October 2001. According to the charge sheet, the complainant and his fiancée were halted in a corner when the appellant was on a night duty. Appellant allegedly told complainant that he wanted to see his fiancée. The complainant complained and did not accept, so the appellant asked him for anything in exchange for letting them go. The next day, the complainant informed top officials leading to an inquiry of appellant. The disciplinary authorities agreed that the appellant charges were proven and terminated him. Honorable High Court allowed the plea of the appellant challenging the termination order and the inquiry report. Honorable Supreme Court on the appeal by CISF observed in a judgment that police officers are not required to do moral policing while upholding the order of disciplinary authority for the removal of CISF constable from service, and Honorable Supreme Court also set aside High Court judgment. The next case is Kumari Lakshmi Saroj versus State of UP. The 15th of December 2021 Act sought health worker applications from females. 5th of January 2022 was the application deadline. According to clause 6 of the advertisement, the candidate must have the required qualifications by the application deadline. This includes completing a 1.5 or 2 year auxiliary nurses and midwives training course, including 6 months of obstetrics training. All appeals were submitted online and tested. After document verification, eligibility was considered. All appellants were MPC registered. All but one appellant filed UP Council applications. MP Council provided no objection certificate. The UP Council issued the registration late, so the appellants could not produce it during the document verification. At the time of document verification, the appellants were not duly registered with Uttar Pradesh Nurses and Midwife Council, Lucknow, and they lacked the essential qualifications. Appellant filed a writ petition before Honorable High Court, but Honorable High Court dismissed it by accepting the state's position that they were not registered with UP Council at the time of document verification and or application form submission, making them ineligible. All original writ petitioners felt aggrieved by impugned judgment and order and appeal by special leave petition before Honorable Supreme Court. Honorable Supreme Court referred to the case of Narendra Singh versus State of Haryana, where the court had specifically laid down the law that if it is found that there is no lapse or delay on the part of the applicant, he cannot be punished for no fault attributable to him. Hence, the order passed by Honorable High Court was set aside, but thereby holding the same be unsustainable. Further, the respondents were directed to appoint the appellants or to the post of health worker female within 6 weeks if they are found meritorious and eligible. Another case is Pramod Singh Kirar versus State of Madhya Pradesh. As of 2013, Pramod Singh Kirar was qualified to be appointed as constable after applying for the position. He stated that he had previously been tried for the offence under Section 498A IPC and had been found not guilty in the case in question. As a result of his involvement in the criminal case, his candidacy was later denied. Honorable Madhya Pradesh High Court upheld his denial, noting that if the candidate was found to have been involved in a criminal case, the employer still has the right to consider antecedents and cannot be forced to appoint the candidate, even in the event of an acquittal or if the employee has made a declaration that accurately describes a finalized criminal case. It was held by Honorable Supreme Court on the appeal filed by Pramod Singh Kirar that the crime for which he was finally found not guilty stemmed from a divorce issue that was ultimately resolved outside of court. Additionally, it was observed by Honorable Supreme Court that a crucial detail in this case was not suppressed by Pramod Singh Kirar, a candidate whose application was turned down because he had been prosecuted under Section 498A of IPC, was ordered to be appointed by the Supreme Court. The last case is from Specific Relief Act 1963. It is Desraj and others versus Rohtash Singh. The appeal was against a judgment dated 15th May 2019 by the Honorable High Court, which dismissed the second appeal of the appellants and affirmed the trial court in a first appellate court decision. The decree allowed the respondent to recover earnest money, which was part of the sale price plus interest. So one of the questions raised before Honorable Supreme Court was whether time was the essence of the contract in the suit for specific performance of contract. It was observed by Honorable Supreme Court that the sale agreements in the present case clearly indicate the intention of the parties to treat time-bound performance as an essential condition. Reliance was placed upon Citadel Fine Pharmaceuticals versus Ramaniyam Real Estate Private Limited and Sardamani Kandappan versus S. Rajalakshmi, wherein it was held the defense under Section 55 of Contract Act is valid against anyone who is seeking the relief of specific performance. Specific performance cannot be granted because the parties clearly intended to make time the essence of contract and the respondent waited too long to file the suit. Another question was whether the appellants willfully avoided their contractual obligations. It was observed by Honorable Supreme Court that where the time was of the essence, the respondent failed to prove that the appellants were willfully avoiding the contractual obligations. The next question was that whether the respondent was entitled to recovery of earnest money. Reference was made by Honorable Supreme Court to Section 22, subsection 2 of Specific Relief Act that unless the plaintiff specifically asks for the refund of the earnest money at the time of filing of the suit or by way of amendment, no such relief can be granted to him. The prayer clause is a sine qua non for a grant of decree or refund of earnest money. Another question answered by Honorable Supreme Court was with regard to even if the respondent was found guilty of breach of contract, the forfeited amount is penal under Section 74 of the Contract Act. For that, reference was made to Section 74 of Contract Act, as well as Fateh Chand versus Balkishan Das, Kailashnath Associates versus DDA, Satish Batra versus Sudhir Rawal, that where the contractual terms clearly provide the factum of the pre-estimate amount being in the nature of earnest money, the onus to prove the same was penal in nature, squarely lies on the party seeking refund of the same. Failure to discharge such burden would treat any pre-estimated amount stipulated in the contract as a genuine pre-estimated loss. So these are all about the judgments of them for the month of December 2022. This shall be our last video for the year 2022. We wish you a very happy and prosperous new year. Till we meet again the next year with a new video. Namaskar.